Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another, and not just any other, but a very special edition of Legal Bites. This is the 50th Legal Bites, which, as I reflect on that, seems overwhelming. I know we have shared an awful lot of laughs, an awful lot of tears, some commotion and contention occasionally over the course of these 50 episodes, but here we are. I'm pretty happy with that number, that accomplishment. I'll also, don't tell anybody, but I'll be turning 50 in July this year, which is a little scary, and I'm less excited about that accomplishment. We haven't reached like Simpsons level numbers or Friends level numbers in terms of episodes, but maybe someday we'll get there. We'll just have to see. So anyhow, if you hang through this whole thing, we've got a special promotion at the very end that you'll have to listen to everything to get to, but a very special promotion to celebrate this 50th episode of Legal Bites. What hotter topic to be talking about on the 50th episode of Legal Bites is more trust accounting confusion. But before you turn it off, you brokers who are sitting there saying, well, gee, I don't hold earnest money on behalf of others in my sales business, and I don't do property management, so none of this stuff applies to me. This is actually more focused at you because we've had some confusion that get clarified in over the course of the last several months and related to trust accounting. So don't just go running off thinking you don't hold earnest money as a brokerage firm and you don't do property management as a brokerage firm, because this is an important thing that you need to consider on another level. All right? So since we had this year's 2020 annual commission update course, which I'm sure all of you took in that first week or two of the year, correct? Right? You're not going to wait until the holidays to take that 2020 update course. But for those of you that have, you know that there's a lot of discussion in this year's update course about trust accounting, property management and trust accounting issues. And that's led to a number of issues. In fact, the last Legal Bites that I did is on setting up a proper trust or escrow account. And so if you haven't watched that, you might want to after you watch this video so you have a better understanding there. But what I want to clarify here is confusion related to who needs to maintain trust accounts. Well, we know if you're a professional property manager or if you're a brokerage firm that holds earnest money on behalf of others and you're holding third-party funds, money that belongs to others, then you know that you have to comply with what is now Chapter 5, the trust accounting rules and expectations. And so there's been a lot of discussion about what specifically some of those are. So that's third-party management services and performing brokerage functions on behalf of third parties. Of course, everybody knows you got to comply with the accounting rules the division has. And then we've got self-managed properties. And so that would be you realtors out there who happen to dabble for yourself in the same business that you work with third parties on in your brokerage service. You buy, own your own investments, and you are a landlord. As a realtor, you happen to be a landlord as well because of properties that you've invested in, you own, and you have landlord-tenant relationships with tenants out there. And as a result of those landlord-tenant relationships, you hold security deposits, let's say, on behalf of those tenants. Now, you don't have to have a brokerage license in order to do that. Anybody can represent themselves as a landlord if you own properties. You only need a license if you're going to do it on behalf of third parties. And you do brokerage services on behalf of third parties, but you also have your own investments, which you do first party. Well, that is not technically considered a brokerage service because you're not doing it for third parties, you're doing it for yourself. But, and that's a big but with a big explanation point, being licensed with the Division of Real Estate to perform third-party brokerage services, which you do, it comes with some additional implications. And some of these are just sort of being discovered by a lot of brokers as they've been going through this update course since January 1st of 2020. So there's Colorado case law that essentially says that the commission has oversight for real estate-related activities which do not require a license, such as managing your own investments, being a landlord on behalf of yourself. So the commission does have, according to the Colorado courts, oversight over that, which means, and this is where people are getting a little bit, say gobsmacked by it, by the ACU this year, that the accounting rules apply to you even if you're doing it on behalf of yourself. Well, what does that mean? All right. So if a realtor is managing properties on their own behalf, or you're doing short-term rentals on your own behalf, short-term rentals, leases for less than 30 days are not a brokerage function specifically, or generally speaking, short-term rentals are not a brokerage function versus long-term leases, which certainly would be. If you're doing things like that, if you are coming in the course of your own personal life into contact and maintaining funds or holding money for third parties, you've got to comply with the rules. And that includes, as a licensee, holding the monies of third parties in escrow accounts or a true third-party fiduciary account. And this is something not just going to your normal bank and naming something a trust account, because that's what you're going to call it. It needs to comply from a depository agreement standpoint with the third-party trust account rules or escrow account rules. And so if you're a licensee and you're holding security deposits for a property that you manage on your own behalf, these rules still apply, which means the trust account still is required to be held in a true third-party beneficiary account. And in connection with that, all of the accounting requirements, including the three-way reconciliation accounting requirement, applies for the maintenance of your own personal property management or investments, okay, even though you're not doing it on behalf of others. So there's even, to be honest with you, according to the Division of Real Estate and the current rules, that should be run through a brokerage firm trust account, because individual brokers aren't maintaining trust accounts. Trust accounts are in the name of the brokerage firm. There might see some changes to that. I know there's some discussions about potentially allowing brokers that are doing it on behalf of just themselves to not hold those monies in a brokerage firm account, but that is technically what the current rule says, and so stay tuned for potentially some updates later this year on that. But I think those two facts that I've just outlined here with regard to how a broker who is licensed doing their own personal stuff has to maintain compliance with Chapter 5 rules, including the third-party account and holding monies there, even if your lease says otherwise, doesn't matter, and performing three-way reconciliation accounting on those third-party money escrow accounts is required. Now, you don't have to have an operating account, obviously, because if you're managing your own properties, you're holding your own money in that account. But if you're holding security deposits or third-party money on behalf of others, you have to do that. So, if you didn't see the last episode of Legal Bites where I talked about what comprises a true escrow account that these monies need to be held in, go back and watch that. I guess it would be episode 49. And be mindful of all of this stuff, because a lot of brokers, as I'm talking to them and doing the ACU, are honestly very surprised by the applicability of these rules to their own personal business. If you have questions, as always, Card Legal Hotline's available from 9 to 12 and 1 to 4. We've gotten to the end, and I promised you a 50th celebration giveaway. The first person to comment on this video in the comments section is going to win 50 cents. We'll mail you 50 cents, 2 quarters. That's, we do what we can here. We don't have a huge budget at the Car Legal Hotline. I think half of that money is coming out of Monica, our fearless production coordinator's pocket, and half of it's going to come out of mine. So we're both in for a quarter, but make your comment and we'll get in touch and figure out where to send, how we'll spend 50 cents or 55 cents mailing you 50 cents. Anyhow, have fun, guys. Thanks, and we'll see you on the next episode of Legal Bites.